Greetings. This is Dr. Welch again for tape 6 on constitutional law questions. The question I have is concerning the Sixth Amendment addresses the right of persons to trial by jury in civil cases. True or false? That would be false, because it is the Seventh Amendment that addresses the right of persons to trial by jury in civil cases. The next question. The United States Constitution was drafted in A, 1986, B, 1787, C, 1788. The correct answer is B. It was drafted in 1787. The next question. The Constitution is a dynamic document that changes over time. True or false? That is true. It does change slowly, but it does change over time. Next, define the exclusionary rule. Okay, the exclusionary rule is very, very important. It came up on the O.J. trial with Judge Ito. What had happened is O.J. had flown to Chicago, and the police officers, instead of getting a warrant, went ahead and searched the Bronco. Well, all of the evidence was excluded under the exclusionary rule because they had not obtained a proper warrant. So if the police make a mistake, then the evidence is excluded under the exclusionary rule. The next question. The language, no state shall deprive any person of life, liberty, or property without due process of law, is contained in A, First Amendment, B, 14th Amendment, C, Fifth Amendment, D, Sixth Amendment. The correct answer is B, 14th Amendment, because it said no state. The federal due process clause is in the Fifth Amendment, so it's important to learn the distinction. The next question. The necessary and proper clause can never stand alone. True or false? That is true. Otherwise, the Congress could be doing everything. What it does is it buttresses the other power, like freedom of speech. It buttresses the other power, like Commerce Clause, and to raise and support armies and all those powers in Article 1, Section 8. But it cannot stand alone. Okay, next one. The First Amendment protects the freedom of speech for which of the following? A, political speech by private citizen. That sounds good. Political speech by businesses. That sounds good. Private speech by businesses. That sounds good. D, all of the above. All of the above is the correct answer. The next question. What are the first 10 amendments to the United States Constitution called? And that is the Bill of Rights. Next, can Congress regulate intrastate, I-N-T-R-A, intrastate commerce? And that would be true if it impacts I-N-T-E-R, interstate commerce. The example is the state of Arizona passed a law that said any trucker going into the state of Arizona had to stop their truck and put on fancy mud guards for the health and safety of the people who live in Arizona. Well, that may take 45 minutes to do, and that was found to be too burdensome on interstate commerce. So even though it was a intrastate rule, it impacted interstate commerce. Now the next one. The part of the Constitution that allows Congress to regulate commerce between states is A, necessary and proper clause, B, interstate trade clause, C, intrastate trade clause, or D, commerce clause. The correct answer is D, commerce clause. Next, what is the significance of the Wickard, W-I-C-K-A-R-D, Wickard versus Filburn, F-I-L-B-U-R-N, Filburn case? This was a case where people were paid agricultural subsidies not to grow crops. But one farmer's wife, I guess, just wanted to make some homemade bread. And so even though they were paid not to grow their wheat, they went ahead and they grew wheat and baked bread. Well, the Attorney General found out about it, and they said in the aggregate, if everyone did that, even though this is just a small impact, if everyone was doing it, there would be fewer trucks going into the markets, and it would have an impact on interstate commerce. And so the growing of bread was regulated under the Commerce Clause. And I think that is as far as the Commerce Clause has ever been reached or ever been selected in terms of this growing of the loaf of bread. In Bates, B-A-T-E-S versus Arizona, the Supreme Court held that the Arizona bar, A, could not regulate legal services, B, could not prohibit ads for legal services. The correct answer would be B, could not prohibit ads for legal services. When I entered law school in 1978, I had to memorize that attorneys could not advertise. But when I graduated in 81, I had to unmemorize it because at that time, attorneys could advertise. It was felt, well, how does a new attorney get started unless he can advertise? But many thought, well, there will be overreaching by the public. And yet for many years now, attorneys have been able to advertise their services, and it's been very helpful. Pharmacy companies have been able to advertise their products. However, that doesn't seem to be as much done recently as in the past. So this is the end of tape 6, and it's good to do these questions to practice the fine points of constitutional